Imagine walking into a courtroom. No lawyer by your side. No legal degree on your wall. Just a folder of old papers and the truth. Now imagine the other side, a team of 3 high-paid attorneys. Expensive suits, leather briefcases, smirks on their faces. They looked at him and laughed, literally laughed inside that courtroom. The judge hadn't even opened his mouth yet. But here's the thing nobody expected that day. That man alone, nervous, holding his old folder, had something none of those lawyers saw coming. One signature, just one signature. And when the judge saw it, the entire room went silent. Stay with me, because this story will change the way you think about justice, power, and what one piece of paper can really do. This is the story of a man we'll call Daniel. Daniel was a 54-year-old construction worker from a small town. He had worked his whole life early mornings, late nights building other people's dreams with his own 2 hands. For 22 years, he worked for a company called Hargrove Construction. No complaints, no lawsuits, no drama. But in 2019, everything changed. The company was sold to new owners, new management came in, and within 3 months, Daniel was fired. No warning, no severance, no explanation. Just a letter that said, "Your services are no longer required." Daniel was shocked. He had given 22 years of his life to that place. He had missed his daughter's school plays. He had skipped family vacations. He had sacrificed for that company. And now, a 2-line letter was supposed to erase all of that? He went to the HR office. They told him to move on. He called the new owner. The call was never picked up. He wrote a formal email. No response. Daniel had no choice. He decided to take them to court. But here's where his real problem started. A labor attorney quoted him $15,000 just to start the case. Another wanted $8,000 up front. Daniel didn't have that kind of money. His savings were almost gone after months of unemployment. His wife was worried. His kids were watching. So he made a decision that everyone around him thought was crazy. He said, "I'll represent myself." For the next 4 months, Daniel did something remarkable. He went to the public library every single day. He studied labor law. He read court case files. He watched legal proceedings on YouTube. He took notes, hundreds of pages of notes. His daughter would later say Dad's dining table disappeared under law books for 4 months. We ate in the living room. He filed his own case. He wrote his own legal brief. He prepared his own arguments. Was it perfect? No. Was it polished? No. But it was real. And it was his. Now the company's lawyers were not worried. At all. During a pre-trial meeting, one of their attorneys reportedly said, "This guy is representing himself? This will be over in 20 minutes. They had done this before. Beat Self represented plaintiffs. Many times. Their strategy drowned him in legal jargon. Make him look confused. Make him look foolish, and the case would fall apart on its own. What they didn't know was that Daniel had found something. Something buried deep inside an old company file. Something that had been signed 14 years ago. He had almost missed it. It was on page 47 of a 200-page document. A small section, just a paragraph. but with a very specific signature at the bottom. He didn't fully understand it at first. But something told him keep this. So he kept it. The day of the trial arrived. Daniel walked into that courtroom alone, a simple folder under his arm, wearing his best shirt, the one he saved for weddings and funerals. On the other side of the room, 3 attorneys. Confident, prepared, almost bored. The lead attorney, Mr. Calloway, didn't even look at Daniel when he walked in. He was busy reviewing papers with his team. When Daniel sat down at the plaintiff's table alone, one of the junior lawyers whispered something to another, and they both smiled. The judge entered. Everyone stood. Be seated. The proceedings began. Calloway's team went first. Smooth, rehearsed, impressive. They argued that Daniel's termination was completely legal, that the new ownership had the right to restructure, that Daniel had been given proper notice according to company policy. They cited 3 different cases. They used legal terminology that filled the room. When they finished, Calloway leaned back in his chair, looking like a man who had already won. Then it was Daniel's turn. He stood up. His hands were shaking slightly. His voice was steady, barely. He began explaining his case. Simple words, clear points. He talked about his 22 years of service. He talked about the verbal promises made to long-term employees. He talked about the company's own employee handbook. Calloway's team occasionally objected. Sometimes the judge sustained. Sometimes he overruled. Daniel pushed through. Then came the moment. Daniel reached into his folder. He pulled out a single sheet of paper. And he said, "Your Honor, I'd like to submit this document as Exhibit C." He walked to the bench and handed it to the judge. The judge looked at it. His expression didn't change at first. Then he looked closer. His eyebrows moved. Just slightly, he turned to Calloway's team. "Counselor, are you aware of this document?" Calloway frowned. He stood up and walked to the bench. He looked at the paper, and for the first time that morning, his face changed. That document was a long-term employee protection clause signed by the original owner of Hargrove Construction 14 years ago. It clearly stated that any employee with over 15 years of service could not be terminated without a formal written review, a 3-month notice period, and a severance package of no less than 1 year's salary. The signature at the bottom belonged to a woman named Linda Hargrove, the founder of the company. And here was the critical part when the company was sold. That clause had been legally transferred with it. The new owners were bound by it. They had fired Daniel, a 22-year employee, with 0 notice, 0 review, 0 severance, in direct violation of a signed legal agreement. Calloway asked for a recess. The judge denied it. The next 2 hours were a different kind of courtroom. Calloway's team scrambled. They argued the clause was outdated. They argued it hadn't been disclosed in the sale documents. They argued it wasn't enforceable. The judge listened to every argument. Then he looked at Daniel. "Do you have anything to add?" Daniel stood up. He said, "Just one thing, Your Honor. The law doesn't have an expiration date when a man gives 22 years of his life." The courtroom was quiet. The judge looked down at the document, then back up. Then he ruled. Daniel was awarded full back pay for the months he was unemployed, 1 full year severance as the clause required, and damages for wrongful termination. Total amount $147,000. Calloway's team sat in silence. Daniel stood there, in his wedding shirt, with his shaking hands now still. He had walked in alone. He walked out with justice. Now I want you to think about something. Daniel didn't win because he was smarter than those lawyers. He didn't win because he had more money or more power. He won because he did one thing that nobody else was willing to do. He refused to give up. He sat in that library every single day. He read things he didn't understand and read them again. He found a document that anyone else would have ignored. And he held on to it. Because somewhere deep inside, he knew the truth was in there. He just had to find it. Here's what I want you to take from this story. The system feels designed to break people like Daniel. People without money. People without connections. People who are told you can't win this. But Linda's signature proved something that day. It proved that one piece of truth properly placed at the right moment is more powerful than any team of expensive lawyers. If this story moved you, if it made you think about the times you almost gave up, hit that like button. Subscribe, because every week we bring you stories just like this. Stories of real people, real fights, real justice. And if you know someone right now who is going through something like this, send them this video. Because sometimes all someone needs to keep going is proof that it's possible.